Murdered your dad.
No, I did
Yes, you
not.
did.
Yeah,
Yes.
Daddy's dead because of you.
Hours of interrogation. Police lying to a suspect in the Inland Empire until he falsely confesses to murder. And now the city of Fontana is paying a massive settlement tonight after police questioned a man for 17 hours until he confessed to killing his father, who's still alive.
What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. Well, you heard exactly what you thought you heard at the end of that initial video. Fontana, California police held, interrogated, and psychologically tortured Thomas Perez Jr. for 17 hours until he confessed to killing someone who was still alive. You guys, if you haven't heard this story yet, are not going to believe the details. So again, it comes to us out of Fontana, California, and specifically the CBS News affiliate there, KCAL. When you're done with this, go head over to their channel and give them credit for sharing the story. So imagine this. You and your dad live together, you get into a slight disagreement. Tempers are flaring. Your dad decides he's going to go clear his head, go for a walk, and he takes the dog. Leaves his wallet, leaves his phone. His intention is just to be gone for a few minutes. A few minutes later, the dog comes back, but your father doesn't. So that's what happened between Thomas Perez Sr. and Thomas Perez Jr. back in August of 2018. Growing increasingly concerned for his father's well-being as more time passed and he wasn't home, Perez Jr. called the police to report his father missing, as any normal person would do. And of course, as luck would have it, and as is often the case, the police take a call for help, and they end up turning the person asking for help into a suspect. And the rest of the story is history. So let's go watch the rest of the video with CBS KCAL, and then we'll come back and talk about the relevant case law.
KCAL News reporter Tom Waite joins us now with what led up to this false and really hard to watch confession.
It was, Pat, and I watched many hours of this intense interrogation, and it's very eye-opening, and we'll get to it in just a second here. But the video of the interrogation is fascinating and disturbing. An innocent man spends hours being grilled by police. When it's over, he's in the throes of a full mental breakdown, and under pressure, he lies to detectives about killing his own father.
We don't think you're a monster, Thomas.
Fontana police detectives grilling Thomas Perez Jr. after Perez Jr. reported his father missing. This interrogation descends into what's being described as psychological torture after the detectives extract a false murder confession from Perez.
We just told you we found your dead dad, and you don't give a.
That detective is lying. Perez Sr. was not dead. But in this moment, Fontana detectives don't know where he is. Perez Jr. reported him missing after they had an argument. A search warrant was served at the family home. Perez Sr.'s wallet, cell phone, and even some bloodstains were discovered. A canine also alerted to the odor of possible human remains. Detectives unleash an unrelenting interrogation of Perez Jr.
Murdered your dad.
No, I did
Yes, you
not.
did.
Yeah,
Yes.
Daddy's dead because of you.
No.
Yes, not only that, but poor Morgan here.
Margot.
Margot had to witness it.
Yep. I walked through the blood.
Yeah.
No.
Yeah.
Yes.
No.
Yeah.
Yes.
The psychological effects of hours of grilling take their toll. Detectives keep pushing. Perez spirals further. Eventually, Perez Jr. makes a false confession to killing his father. All this, and 71-year-old Perez Sr. was alive. He went to his girlfriend's home, but didn't have his cell phone. Perez Jr.'s attorney.
The worst act of deliberate cruelty that I've seen suing the police for 40 years.
Steering on behalf of Perez Jr. sued Fontana and won a nearly $900,000 settlement. This all unfolded back in 2018, but the case was just finalized.
I never thought that it was easy, maybe even possible, to get a completely innocent person confess to something like that. But after I watched the video and watched the interrogation of Tom Perez, what I divined is that they could get you and I to confess to killing Abe Lincoln if they wanted to. It's unbelievable. And they're not amateurs, and they know what they're doing.
So obviously this case begs the question, are the police allowed to lie to someone in the process of interrogating them? Now the answer comes from a United States Supreme Court case from 1969 called Frazier v. Cupp, and then it's case history progeny, and you won't be surprised to learn that there's a much larger list of things they can do than there is a list of things they can't do. So in Frazier v. Cupp, this is a case where two cousins end up killing a guy. The cops isolated them, and they bring Frazier in, and they tell him falsely that his co-defendant, his cousin, has already confessed to the crime. And then Frazier began to make some incriminating statements, and he ultimately ends up giving a written confession. Frazier's convicted of murder, he appeals, and the court looks at it and said, look, deceptive interrogation tactics alone do not necessarily render a confession involuntary. And that was where it started. Then, fast forward 3.5 decades, in 2004, the Ninth Circuit took up a case still citing Frazier, and a case that came later called Miller, but this case was called United States versus Crawford. Now in Crawford, you basically have a guy who's on parole, he has a parole officer, and then you have an FBI agent who's investigating some bank robberies, and they hear his name continue to pop up. So the FBI agent gets with the parole officer, and they kind of pop in on Crawford. So the FBI agent ends up getting with Crawford's parole officer, and they pop in on him under the guise that they want to do a parole search. In reality, what this agent and the parole officer wanted to do was they wanted to isolate him, get him comfortable, and make him feel like he had to talk to them so that the FBI agent could get some information about these bank robberies that he's been hearing this guy's name involved in. If you don't know, probationers and parolees have special rules governing search and seizure. Parolees in most states have what is considered to be a reduced Fourth Amendment right to privacy, and many are considered to still be under the supervision of the warden of the facility from which they were released. So in many cases, they have about as much expectation of privacy as they would have in a cell in the facility where the warden is supervising. People under supervision essentially give express consent to searches by their probation or parole officer as a condition to either on probation avoiding prison to begin with, or on parole getting out of prison early. So in the same way you fill out an implied consent for your driver's license where you say that under certain circumstances I'm going to submit my blood or breath, they do an express consent as a condition of their supervision that says, look, if your parole or probation officer shows up at your house and they want to search, you have to let them search. They can still deny the search, although many of them don't realize they can. But there are always going to be consequences attached to that decision. So it's not like they actually give up their Fourth Amendment right in that they don't have a constitutional right. It's they give consent to the search up front. Now, just like any other case of consent, they can revoke the consent with consequences, but most of them don't realize that. In the same way that people think that if they tell the police no for a chemical test or a field sobriety test, that means automatically their driver's license is suspended. Somebody on probation or parole think in many cases that if they tell their probation or parole officer no, they can't search it, they're automatically going to prison, and that's not actually the case. Now, again, there are going to be consequences. You're probably going to get a violation filed, but this is what I tell my people on supervision. If the thing that they're going to catch you with when they do the search that you let them do is worse than the sentence that you're fixing to serve if they revoke you. So in other words, if your worst day in court for denying the search is that you're going to go serve the rest of a 3-year sentence, but the worst day in court when they find what you have in there that you're going to let them search and find is 10 years, well, then deny the search and take the 3 years. I mean, it's really just a risk versus reward calculation. So if you've got 10 pounds of methamphetamine and you're going for 10, or you can deny the search and you're getting revoked on your probation and you're going to serve the remainder of the 3 you have left, it's a fairly easy decision, right? So if the 3-year sentence you're going to get remanded for is a hell of a sight better than going down and cooperating at the police station and confessing to a couple robberies like our boy Crawford did here, then you're better off to just say, no, I'm not interested in cooperating. But this is what happened. Crawford goes voluntarily to the FBI office. He ends up giving a confession. He gets convicted. And the underlying search ends up getting thrown out on Fourth Amendment grounds. But his statements that he made, even though the officer told him some lies in the process of the interrogation, the statements that he made get upheld. And they are considered voluntary. And he is convicted solely on the things that he says to the FBI agent. And again, in that case, that's United States versus Crawford. The court said basically unless the cops use physical force or psychological pressure, or they make threats threats or promises, deceptive interrogation tactics do not necessarily render a confession involuntary. So what's different about this case? Well, the fine protectors of the public in Fontana didn't use force, and they didn't make promises, but they did use psychological pressure, and they definitely made threats. Specifically, they locked him in an interrogation room for 17 hours. They told him that if he didn't confess and tell him where his dad's body was, they were going to have his dog euthanized. And then they brought the dog into the interview room with him. They told him that they knew he killed his dad, he stabbed his dad, he forced the dog to watch it, and forced the dog to walk through the blood after witness it. All of this is nonsense. It never happened. His dad's still alive. Again, they held him for 17 hours until he had a mental breakdown and eventually confessed to a murder that never happened. They even had the guy sent to a mental hospital for evaluation for damage that they caused through their interrogation tactics, and he was involuntarily committed as a result. And this was after they had information that his father was found alive and safe. So his lawyer ends up suing, and they end up settling for a little under $900,000. Pathetically, this happened in 2018. They just now settled it in the last couple days. And the lawyer basically said, look, qualified immunity is such a problem. We took the settlement because we were a little bit afraid that they were going to toss the suit if we went too far with it on qualified immunity grounds. So $900,000 was acceptable to us to avoid that risk. Another thing the lawyer said that you may have heard in that story was that in 40 years of practicing law and suing the police, he had never seen a worse case of an intentional cruelty exacted on a person they were trying to get a confession out of. So my closing argument is, the very worst part of this is that it took 2018 to 2024 to get it resolved because they knew what they did was wrong. If they were smart, they would have just settled this case right up front. 2, some of the officers are still employed. They haven't faced any consequences for this, and the taxpayers are on the hook. So the taxpayers get to pay for the police officers who abuse this guy and prepay for the officers who are going to show up to their house for 911 calls and abuse them in the future, and nobody gets held accountable for it. It is a miscarriage of justice in the worst possible way. This kind of crap is the reason that people don't trust the police. And look, I know this might sound terrible or crazy or whatever, but I'm an animal lover. I care what happens to people, but I get devastated over somebody being cruel or threatening to hurt animals. Like, we don't deserve the unconditional love that we get from animals as human beings, and I can't even watch those videos of cops like killing dogs for no reason. It disturbs my peace in a way that almost nothing else does. Hurting kids, hurting old people, hurting animals, they're like the worst for me. You do what you want to me, but you start threatening to euthanize my dog, and that's a bridge too far, and I'm telling you, it's about to go down. Like, there is an important lesson to be learned here, though. The police have no obligation ever to tell you the truth. And whether you believe this or not, they are going to assume almost everything you tell them is a lie or there's some subterfuge going on, and they're going to try to hem you up in any way they can, even if you're calling them for help, as is the case here. So likewise, you should just assume that whatever they're telling you is misleading or has an ulterior motive or is just flat out false, because their ultimate goal is to get you to confess so that their job is easier and they don't have to actually do the investigation. They want you to investigate yourself, and people do it all the time, so they keep trying to get people to do it more. And when I say keep your evidence to yourself at the end of my videos, this is exactly what I mean. The cops enter your house without a warrant, you challenge the search, evidence goes away because of the exclusionary rule, otherwise known as fruit of the poisonous tree. They hold you too long on a traffic stop waiting for a canine, or they search your car without probable cause, Rodriguez violation, fruit of the poisonous tree. You have standing to challenge that search, and you can get the evidence excluded. But if the evidence comes from you and that big mouth of yours, there are very, very limited ways to keep it out. See, most of you guys have heard the word hearsay, and you hear other people talking about it, and they'll say, well, that's just hearsay. That's not really what hearsay means. Most people don't understand what hearsay actually means. There's a very specific legal definition of hearsay. These are the words, and they're confusing, so I'll break it down. Hearsay is an out-of-court statement offered in court to prove the truth of the matter asserted. Now, that is a bunch of legal mumbo-jumbo. This is what it means. Sally said a thing outside of the courtroom. As a lawyer, I want to tell the court what Sally said, and I want to do it for the specific purpose of proving that the thing she said is true. So I've offered an out-of-court statement in court to prove the thing that was asserted in the statement is the truth. Now, if that was Sally and she wasn't involved, or she was a bystander or a witness, it's hearsay, and there's only certain exceptions that make it able to come in. But when it's a defendant or an opposing party, like in a divorce or something like that, but specifically if it's a defendant in a criminal matter, that statement almost always is coming in, because the rules of evidence specifically exclude statements of opposing party under the definition of hearsay. In fact, a brand new category is made up for things like this, and it's called not hearsay or non-hearsay. So even though it's a statement out of court, offered in court for the truth of the matter asserted, it's definition hearsay, the rules of evidence carve out this little nook where this can exist and it not be hearsay. So that Miranda warning, where it says anything you say can and will be used against you in the court of law, that is almost always the truth. Anything you say can and will be used against you in a court of law. That's all for this one, guys. Be sure to like and subscribe. This is a crazy case. Leave me a comment and let me know what you think about it. Check out some of the other videos on my channel. Leave me a comment on there as well. Until I see you again, take care. Always film your interactions with the police. And for the love of everything holy, keep your evidence to yourself.